Good morning. This is Rajesh Kumar. Today we are going to analyze two concepts of contract law, that is economic duress and undue influence. The video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. The theory question: the law relating to economic duress is easy to state and to apply. The same cannot be said of the law relating to undue influence. We have to discuss and analyze this statement. Economic duress occurs when a party is forced into a contract or contractual variation under illegitimate economic pressure. The central focus is on whether the parties concerned to the contract was genuine. A contract entered into under economic duress is voidable, allowing the victim to resign the contract. In other words, economic duress arises when illegitimate economic pressure forces a party to enter a contract against their free will. It generally requires three elements. The first one is illegitimate pressure. The pressure must be unlawful or improper, often involving a threat to a breach a contract without justification, as in the case of the Atlantic Baron and the Atlas Express versus Capco. In the Atlantic Baron, economic duress was recognized because a threat to withhold delivery, that means without legal basis, left the plaintiff with no real alternative. This established that economic duress need not involve the oath force but may include a threat to a party's economic interest. In Atlantic Baron case, the shipbuilder threatened to stop the work unless the buyer paid an additional sum. The court found that the pressure was illegitimate because the buyers were coerced into agreeing to the price increase. Whereas in Atlas Express Limited versus Capco Limited in 1989, it's also demonstrated this point where Capco was forced to agree to a revised contract under the threat of Atlas withdrawing its delivery services, which would have severely affected Capco's business. The second one, the compulsion of will. The claimant must show that they had no practical choice but to comply. In Pakistan Airlines versus Times Travel, the Supreme Court reinforced that compulsion which states a genuine consent. Here, Pakistan Airlines required agents to agree to unfavorable terms by threatening to terminate the contracts, a decision deemed illegitimate due to the absence of genuine negotiation. Whereas in causation, there must be a direct link between the pressure exerted and the decision to enter into a contract. The factor is important in cases like power on versus law in long case, which underscore that economic pressure must be significant enough to affect the claimant's decision to contract. There is a lack of realistic alternative. The victim must have no reasonable alternative but to submit to the pressure. In Pakistan International Airlines Corporation versus Times Travel Limited 2021, the UK Supreme Court reaffirmed this requirement, noting that a threat of lawful action, that is terminating a contract, does not always constitute illegitimate pressure unless it deprives the victim of any realistic option. The Supreme Court decision in Pakistan Airlines versus Times Travel illustrated the high threshold required to establish economic dues. The court emphasized that simply using a commercial leverage does not amount to duress unless it deprives the claimant of any practical alternative. This requirement ensures that economic duress remains focused on clear-cut cases where illegitimate pressure directly forces the concern. What about the ease of application? The law of economic duress is relatively straightforward to apply. Courts primarily focus on existence of illegitimate pressure and lack of reasonable alternatives. Cases such as Atlantic Baron versus Atlas Cafco clearly delineates the boundaries of the doctrine, making it easier to identify when duress is present. In Pakistan Airlines versus Times Travel, the court clarified that lawful actions can amount to duress but only if the pressure exerted is so corrosive that it leaves the victim with no meaningful choice. This clarification has refined but not overly complicated the doctrine. Let's move on to the another topic of undue influence. In contrast to economic duress, undue influence involves the exploitation of a relationship of the trust or confidence to obtain an unfair advantage. A doctrine of undue influence is more challenging to define and apply due to the wide variety of relationship and circumstances in which it can arise. In other words, unlike the economic duress, undue influence deals with improper influence over a party, often within the relationship, where the trust and confidence are placed in the influencer. The undue influence can be classified into two categories. The first one is the actual undue influence. The second one is presumed undue influence. When actual undue influence, the claimant must prove the actual pressure on influence that were exerted to manipulate their decisions. In Lloyds Bank versus Bernty, the law journey emphasized that undue influence often exists within the relationship of confidence, such as those between the banker and the customer, where one party is susceptible to manipulations. In Lloyd's Bank versus Bounty case, the court found that a bank had exerted actual undue influence over an elderly man to obtain the security over his home. The court held that a bank took unfair advantage of the relationship and the man's trust in the bank. Whereas the presumed undue influences might arise where a special relationship of trust and confidence exists, and the transactions calls for an explanation. In Barclays Bank PLC versus O'Brien in 1994 is a landmark case in this area where the court presumed undue influence because the wife had been misled about the nature of transaction. The court ruled that bank must take the steps to ensure that parties entering into such transaction do so independently and freely. Whereas in the case of the Royal Bank of Scotland versus Etridge, the further clarified the law establishing that if undue influence is presumed, the party benefiting from the transaction must prove that the other party entered into the contract freely. The court also providing a practical guidance for the banks, outlining the steps they must take to avoid being tainted by undue influence in relationship involving guarantors and third parties. In other words, the presumed undue influence arises where there is a pre-existing relationship of the trust and the transaction appears disadvantageous to the influenced parties. A Barclay Bank was Brian is a pivotal case for presumed undue influence as it established that bank must ensure independent advice when a spouse guarantees their partner's debt. This case, along with RBS versus Etridge, stressed the duty of the parties in a stronger position to ensure that the influenced party acts freely and with informed consent. What is the complexity in application? While the basic principle of undue influence are easy to state, the doctrine becomes more complex when applied. The requirement for proof in case of actual undue influence is often clear, but the concept of presumed undue influence introduces significant complexity. The presumption of undue influence arises in certain relationship, example, the parent-child, solicitor, and the client, but it can extend to other relationships depending on the facts. The subtle difference between the actual and the presumed undue influence and the burden of proofs make this area of law more intricate than economic jurors. The Etridge case, while helpful in clarifying the steps necessary to avoid undue influence, also exemplifies the complexity. The court provided a detailed guidance on how banks should manage situations where the undue influence might be presumed, but this guidance can be difficult to apply in practice, especially in determining when the presumption arises, how the bank can rebut it. Let's compare both these concepts. What about the clarity of definition? Economic duress, usually, the definition of economic duress is relatively simple, focusing on the concept of illegitimate pressure and the absence of alternatives. The case law has consistently redefined these principles without overcomplicating them. Whereas in the undue influence, the definition is more nuanced, particularly with the distinction between actual and presumed. The presumption of undue influence in particular makes the doctrine more difficult to apply consistently. What about the ease of application? Economic duress. The application of economic duress is relatively straightforward because it is grounded in objective criteria such as the nature of the pressure and the available alternatives. Courts can usually apply the law with little difficulties, as seen in the Atlantic Baron and Pakistan Airlines versus Times Travel case. Whereas the undue influence, the application is more complicated. The doctrine requires a deep analysis of the relationship between the parties, the circumstances of the transactions, and the procedural fairness of the agreement. The ethics guidelines, while helpful, introduces a further complexity for financial institutions and other third parties who must take care of who must take care to avoid being implicated in undue influence and claims. What about judicial discretion? Economic duress doctrine leaves little room for the judicial discretions once the key elements are established. If illegitimate pressure and the lack of alternatives are proven, the contract can be resigned. Whereas in undue influence, the allow for more judicial discretions, particularly in cases of presumed undue influence. The judge must decide whether the presumption applies, whether the dominant party has rebutted the presumption, and whether the victim entered into the contract freely. This adds a level of uncertainty and complexity. The critics argue that doctrine of economic duress is clear and easier to apply than anti-influence because it focuses on tangible economic pressure, often observable and quantifiable. In contrast, anti-influence is more abstract as it hinges on the subtleties of the relationship and the psychological impact of influence. Lord Nicholas in Orbius vs. Edrich noted that anti-influence lacks a precise definition due to the wider ranging forms of influence that can arise in various relationships. This fluidity makes anti-influence inherently subjective, complicating its application. The law related to economic duress is relatively straightforward and easy to apply. The courts have developed clear principles, and the doctrine is based on the objective elements, making it predictable and consistent in its applications. In contrast, the relating to undue influence is more complex. The distinction between actual and presumed undue influence, the varied relationship in which undue influence can arise, and the burden shifting the mechanism all make these areas of law more difficult to apply. The need for judicial discretion is in presumed undue influence cases, combined with the procedural safeguards outlined in a reach, adds layers of complexity that makes undue influence less predictable and harder to navigate than economic duress. Thank you.